Bill hearing the matter of an application by Rosaleen Dalton for judicial review.
Please, my lords, my ladies, I appear for the respondent, the appellant in this matter, with my learned friend Mr. Compton, for the respondent, my learned friend Ms. Doherty, QC, and Mr. McGowan appear. This is an appeal from a decision of the Northern Ireland Court of Appeal, handed down in April 2020. The legal issues in the case centred upon the application of Article 2 of the European Convention on Human Rights. And that judgment in April 2020 was promulgated at a time when the jurisprudence in Article 2 cases was in a state of some flux. I think at least 4 members of this panel also sat on the panel that dealt with the appeals of McQuillan and Hooded Men, which were heard in June 2021, with a decision issued in December 2021. And this appeal brings forward another issue in respect of the application of the Article 2 jurisprudence in domestic law. The factual background to the appeal is set out in the Court of Appeal judgment and the Statement of Facts and Issues. It relates to a claim that the Attorney General for Northern Ireland was compelled by Article 2 of the Convention to direct a fresh inquest pursuant to Section 14 of the Coroner's Northern Ireland Act into the death of the respondent's father. He was killed in an IRA bombing on the 31st of August 1988, and the next of kin are in court today. The death in question occurred some 12 years and 1 month before the commencement of the Human Rights Act, 1998, on the 2nd of October 2000. And the Attorney General for Northern Ireland declined to direct a further inquest be held, and that gave rise to judicial proceedings in the Northern Ireland High Court. The judgment of Mr. Justice Deeney dismissed the application for judicial review, and that was appealed to the Northern Ireland Court of Appeal, who reversed the decision. They held that the Article 2 procedural obligation to investigate was engaged because the obligation had been revived as a consequence of the Brecknell test, and also because the genuine connection test, as it's known, had been satisfied. And the order of those findings has some significance, and I'll return to that. The Court, as the Court of Appeal did on a number of occasions, focused on the Brecknell test first and the genuine connection test second. And we say that was an incorrect approach in law. This is an area of law which, as Mr. Justice McGuire and the Court of Appeal found in this case, had been subject to many twists and turns by the time the appeal was heard and judgment given in 2020. And it might assist the Court if I give a sketch of some of the key points in the developing jurisprudence, and I'll come back and develop some points out of this as we go. And again, I'm aware that some members of the panel will have a greater familiarity with this from the McQuillan appeal. Starting point from the perspective of what we have to deal with today is the judgment of the House of Lords in Macaire in 2004. And Macaire was another Northern Ireland case on which the question of the retrospective effect, if any, of the Human Rights Act was considered. And the House of Lords focused on the primacy of Section 22, subsection 4 of the Human Rights Act, and stated clearly that the Act did not have a retrospective effect. In 2009, there's a decision of the Grand Chamber in a case which I will mispronounce probably as Silic and Slovenia, a Grand Chamber decision arising out of a medical negligence case in that country, where a death had occurred in 1993, just over a year before the ratification of the Convention by Slovenia in 1994. And I'll say a little bit more about that case because that's pivotal to the concept of genuine connection. It's the genesis of the concept of genuine connection, and it has been applied or misapplied in a series of cases thereafter. In May 2011, this court handed down judgment in the case of McCaughey, again, another Northern Ireland case, a coronial case where it had been contended that in light of the decision in the Slovenian case, an inquest into a death which occurred in 1990 would have to comply with the Article 2 obligations that attach thereto. And the Court of Macaulay considered the application of the Macaire judgment, considered the principles that emerged through citation Slovenia, and gave a judgment, 6 judges with 1 dissent from Lord Roger addressing this issue. And again, I'll say a little bit more about the treatment of genuine connection in Macaulay. In 2015, this court gave judgment in the case of Caillou, a case arising from a massacre in Malaya in 1948, alleged to have involved service personnel. And in that judgment, Lord Neuberger again examined closely the question of the application of the genuine connection test, as did Lord Kerr. And I'll take you to some key passages from the judgment in Caillou in due course. In 2019, in February, this court gave judgment in the case of Finucane, another Northern Ireland case, judgments by Lord Kerr and Lord Carnwath, a case which dealt with questions of legitimate expectation and also the application of Article 2. And the treatment of the Article 2 genuine connection test in that judgment is of central importance to the later development of the Court of Appeal jurisprudence in Northern Ireland. Pausing there, as of February 2019, there were 2 important appeals in travel in the Northern Ireland legal system. They were the McQuillan case and the Hooded Men case. So they had been heard, but judgment had not issued. This case, Dalton, had also been heard. Judgment was given in the McQuillan case in March 2019. Lord Chief Justice Morgan, Lord Stevens, as he is now, Sir Paul Girvan on the panel. And the McGuigan decision was given in September 2019. The Northern Ireland Court of Appeal unusually departed from its usual course and granted leave to appeal to the Supreme Court in December 2019. The chronology is important because judgment in this case, Dalton, was handed down in April 2020. And one of the points which we'll develop is the application of the McQuillan approach in this case at a time when it was actually under appeal in this court. And when this court came to give judgment in McQuillan in December 2021, we say it exposed an obvious error in the reasoning in the Dalton appeal. So as I've said, the McGuigan and McKenna case were heard together in June 2021, judgment issued on the 15th of December 2021, and on the same date, a panel of 3 justices from this court granted permission to appeal in this case. And that brings us before this court. In the course of these submissions, I intend to address 3 topics. The first is related to the genuine connection, and posing the question of whether or not the genuine connection test is met in a case where the death occurs more than 10 years before the commencement of the Human Rights Act 1998. In this case, the death in question, as I've indicated, occurred 12 years and 1 month before the commencement of the Act. The second topic is if that genuine connection test is met, what is the scope of what's called the Brecknell Revival Doctrine? And did it revive the Article 2 procedural obligation in this case? The third question is whether, if that Article 2 obligation has been revived, is the Attorney General for Northern Ireland obliged as a matter of law to direct that a further inquest be convened, or are the existing processes, previous investigations and ongoing civil proceedings sufficient to discharge that obligation? Those are sequential questions. If the court with us in our submissions on the first topic, the second and third may fall away. So the focus of our submissions is on, firstly, the genuine connection test. At the outset, it's, in our submission, worth turning again to the origins of what is called the genuine connection test, and that's in the Grand Chamber decision in citation, Slovenia. The court will have that at electronic page 1581. And this, as I've indicated already, was a clinical negligence type case where there was a short gap between the death in question and the ratification by Slovenia of the European Convention, just over 1 year. So it was a close proximity case. And the Grand Chamber developed its jurisprudence in respect of the Article 2 procedural obligation in a significant way. It took a step that hadn't previously been taken and found paragraph 159, this is page 1615 in the electronic bundle, that the procedural obligation had evolved into a separate and autonomous duty, and it could now be considered to be detachable. A detachable obligation arising out of Article 2, capable of binding the state even when the death took place before the critical date. That's the key development, was the detachability of this procedural obligation. Hitherto, it had been considered something that was aligned and intertwined specifically with the substantive obligation. The court recognised that adopting this concept of a detachable investigative obligation posed problems for legal certainty. It's actually a feature of the judgment that every judge who was involved in the judgment raised concerns about legal certainty. So it's in the main judgment, it's in the concurring judgment of Judge Lawrenson. There are two other concurring judgments which also raise questions about legal certainty, and the dissenting judgment of Judges Bratza and Turman very pointedly raises concerns about the application of this particular approach. The legal certainty issue is flagged by the majority of paragraph 161, and you'll see it refers to having regard to the principle of legal certainty, the court's temporal jurisdiction as regards compliance with the procedural obligations of Article 2 in respect of deaths that occur before the critical date is not open-ended. So recognising there's a potential legal certainty issue, it's not open-ended, and that was addressed in the following paragraphs, and this is the source of the genuine connection test. First, it's clear that where the death occurred before the critical date, only procedural acts and or omissions occurring after that date can fall within the court's temporal jurisdiction. Secondly, there must be a genuine connection between the death and the entry into force of the convention in respect of the respondent state for the obligations. So there one has the genuine connection concept. There are obvious difficulties which the court recognised and later courts recognised with that concept. What do the words genuine connection mean? What does genuine import? It's not an obviously juridical concept. What is it meant to convey? Is it something more than simply a temporal connection? It must be, it would appear. What does connection mean? The second paragraph of paragraph 163 appears to elaborate upon that in a problematic passage beginning with the word thus. Full text of that paragraph reflects not a normative statement, but a predicative, empirical statement, which is difficult to apply in any particular case. So the genuine connection test, articulated as it is there in 163, had a further element, which is expressed in slightly opaque terms, with the paragraph beginning, however. There's a reference to the connection being based on the need to ensure the guarantees and underlying values of the Convention are protected in a real and effective manner. So this is an additional element. Those were the component parts of the court's attempt to address the legal certainty concerns and avoid the problem of an open-ended obligation to conduct investigations. And the acknowledgements within that part of the judgment that this is a difficulty. The concurring judgment of Justice Lawrenson highlights The problems is page 1629 in the electronic bundle. At third paragraph of his opinion, he notes the problems with legal certainty caused by these criteria. He, at the bottom of that paragraph, expresses the view that he finds it incompatible with the intention in respect of legal certainty to respect the principle of legal certainty to define the court's temporal jurisdiction in such a vague and far-reaching way. In his view, there must be a clear temporal connection, and he restates that in paragraph 15. The dissenting judgments of Judge Bratza and Terman are found at page 1635, and they too questioned this approach at paragraph 14 of their judgment, page 1638. They don't quarrel with the observation that there's a separate and autonomous duty in procedural terms for Article 2, but they differ on whether it's detachable, in the sense it's an obligation to be imposed in the state after the date of ratification, even where the death took place before that date. And at paragraph 15, they raise further objections, noting an inconsistency with the court's approach. And at 16, they note it gives rise to serious issues of legal certainty. They refer then to the genuine connection test and say that it's unclear whether what's meant is a close temporal link between the two or some other, and if so, what connection. And they then say at the end of paragraph 17 that uncertainty is compounded by the last paragraph of 163 of the judgment, the convention values point. So in that judgment itself are the seeds of the problems that have led to litigation in Northern Ireland in the succeeding decade about the scope of the application of Article 2. McQuillan and Hooded Men are an example of that. This case is another. And cases continue in the High Court about what is meant by genuine connection, particularly now in respect of a cohort of cases relating to deaths between 1990 and 1992. The problems with the genuine connection test were also apparent to the Supreme Court when it came to consider the issue in McCaughey. You have the McCaughey judgment at electronic 790. And McCaughey was a case about whether or not there is now an obligation in a 1990 case, if a genuine connection is established, to conduct an inquest in a manner that complies with the Article 2 procedural judgments. The justices, again, here also expressed concern. References from Lord Phillips, paragraph 46, page 811, the electronic bundle. He noted that the meaning of the Grand Chamber decision was far from clear. Lord Hope, paragraph 73, said only the most starry-eyed admirer of the Strasbourg Court could describe the guidance at paragraph 163 of the Silly case as clear. Lord Brown, paragraph 100, said it was deeply unsatisfactory as purported delineage. Lord Dyson, paragraph 121, page 830, noted it had been, with justification, subject to trenchant criticism. And Lord Roger, who dissented, paragraph 151, said it would be a work of supererogation for him to criticise the court's legal analysis in paragraph 163 or to emphasise the blow to legal certainty which it struck. And again, we say those observations are prophetic because the legal certainty problem persisted right through the rest of that decade and into the cases which we're dealing with today. The problems arising from the Slovenian judgment were recognised by the Grand Chamber itself and returned to the topic in the decision in Janovic and Russia. And you'll find that in the electronic bundle at 1641. Janovic again, members of the panel will be familiar with this, but arose out of the massacre of large numbers of Polish officers and soldiers by the Russian Red Army in 1940. And a question was raised as to whether or not there was an Article 2 obligation to reinvestigate those atrocities. The court took the opportunity to go back to the ground it had covered in the Slovenian case. And you'll see that at page 1676, paragraph 140. And the heading the Grand Chamber imposes here is clarification of the silly criteria. And this is important in the sense that later in the Supreme Court there is some debate and discussion about whether the dominant decision is the Slovenian decision or Janovic. And what we say is clear is the Grand Chamber set out to clarify its position in Janovic. Paragraph 141 summarises the criteria from the Slovenian case, paragraphs 162 and 163, and that's a straightforward summary of that. It deals then with the procedural acts and omissions in the post-entry into force period. And the paragraphs that follow at 143 are and have been the subject of considerable judicial scrutiny and debate. The question of the genuine connection is considered at paragraph 144. There's a reference to omissions, a reference to obligations being triggered, where a plausible, credible allegation, piece of evidence, or item of information comes to light which is relevant to the identification and eventual prosecution or some punishment of those responsible. That's the Brecknell test inserted into that paragraph. The last sentence of this paragraph is of key importance and has been the subject of the Northern Ireland Court of Appeal's reasoning in all of the recent cases. What the Grand Chamber said is, in the last sentence, if the triggering event lies outside the court's jurisdiction ratio temporis, the discovery of new material after the critical date may give rise to a fresh obligation to investigate only if either the genuine connection test or the convention values test discussed below have been met. So the analytical approach is, first of all, to determine whether or not the genuine connection test is met, and it elaborates on that in a moment. And only if it has, or if the convention values test has been met, do you turn to consider Brecknell-type triggering events. And as we'd see, what the Court of Appeal did in all of the recent cases was approach the problem from the other way and address the Brecknell point first and then considered the genuine connection. The genuine connection test is then exposed in much greater detail in paragraphs 145 and following. And of particular importance is paragraph 146, where the Grand Chamber states that the time factor is the first and most crucial indicator of the genuine nature of the connection. So the temporal point is the first and most crucial indicator. It notes then, as it previously had done, that the lapse between the triggering event and the critical date must remain reasonably short if it's to comply with the genuine connection standard. Then, another important sentence, which we'll see again, although there are no apparent legal criteria by which the absolute limit on the duration of that period may be defined, it should not exceed 10 years. So here we have the introduction of the 10-year limit, described as a limit, described as an absolute limit. The next sentence then indicates that even if, in exceptional circumstances, it may be justified to extend the time limit further into the past, it should be done on condition that the requirements of the convention values test have been met. So, an objective reading of that paragraph would indicate the imposition of an apparently absolute 10-year limit, subject to a possibility of extension if a threshold condition was met. The threshold condition is that the convention values requirements have been engaged. So that's a high threshold condition. We know it's a high threshold condition because if we study the Strasbourg jurisprudence, there are no examples of the convention values threshold having been met. So the temporal obligation is profound.
Well, since the convention value test is a separate test, it's just saying that it's really saying that you're going to meet that separate test, isn't it?
Yes. It's only if you do that there's then the prospect of any movement on the 10-year limit. The paragraph 147 says that the temporal period is of itself not decisive, because it then goes into the second sentence in paragraph 163 of the Sillage case, and this involves the consideration of what has been done or not been done since the critical date. And the critical date here, of course, is the commencement of the Human Rights Act. Paragraph 148 makes the position clear, we say. Having regard to the above, the court finds that for a genuine connection to be established, both criteria must be satisfied. The period of time between the death as a triggering event and the entry into force of the convention must have been reasonably short, and a major part of the investigation must have been carried out or ought to have been carried out after the entry into force. So if the temporal point is not met, then the empirical analysis of what has been done or ought to have been done, which is a problematic concept in itself, does not have to be examined. If the temporal point is met, then we go into an analysis of what has or hasn't been done and weigh that in the balance. So again, we say the temporal point is critical. The convention values issue is addressed in paragraph 150. Again, the court will be familiar with this. It's referred to as something that's of a larger dimension than the ordinary criminal offence, something that amounts to the negation of the very foundations of the convention: serious crimes under international law, war crimes, genocide, or crimes against humanity. So the court places that as the threshold condition for departure from the genuine connection test. The Janovich decision clearly clarified what had been the unsatisfactory residual position after Sillage and indeed after McCaughey. The matter came back before this court in the case of KU in 2015. You have a reference to that at page 841 of the electronic bundle. KU is the case that arose about the killing of 24 unarmed civilians.
Could I just mention, while we have this in front of us, that the court first have the official law reports rather than, for example, the All Englands, as in this case, if a judgment is available in the official law reports. And it's also helpful to have the PDF of the law report rather than the format we have here. It's more readily legible, simply.
I fully agree, my Lord. I think for some of these decisions, there are no appeal cases versions yet available, but for others there are. Point is certainly noted. The court can see from 841 the panel who were dealing with the KU case. It was another case about the reach of Article 2. In this case, whether it reached back to 1948, to the date of the incident that was under consideration here. It's of significance for our purposes because the court again grapples with the application of Janovich and the genuine connection test. And it's important for the debate we're having because there is a discussion here about whether or not the Supreme Court can again look at decisions that is made on this topic or finesse them, or depart from them. So it is important to see what exactly has already been considered and decided in this context. And you'll see here, for example, page 861, Lord Neuberger, giving the leading judgment of the case, recognises that the law had recently been clarified by the Grand Chamber in Janovich, and notes that almost all the applicable principles can be taken from that case for present purposes. Paragraph 76, page 862, he cites the paragraph I've just shown you, paragraph 146, about the lapse of time, the limit, and the 10-year rule. 77, he refers to the 10-year period being used to calculate the dates. And again, at 78, refers to consideration of the 10-year period. Paragraphs 87 through to 89 again, Lord Neuberger is referring to the 10-year rule and going back more than 10 years. He refers at paragraph 87 to 144 of Janovich, which I've shown you. At paragraph 89, page 865, notes that it follows: as far as the appellant's claim is based on Article 2, it fails because the Strasbourg Court would rule it inadmissible as the killings occurred more than 10 years before the UK citizens had the right to petition the Strasbourg Court. And then 90, there's some discussion about a difference of view between the justices. Lady Hale, Lord Kerr, Lord Neuberger took slightly different approaches. But at the end of the paragraph, you'll see, beginning word secondly, Lord Neuberger notes it's a topic in which clarity and consistency is highly desirable. Unless the guidance from Strasbourg seemed unclear, incoherent, unworkable, I'd be reluctant not to follow and apply it. Having permitted a degree of retroactivity, I believe the Strasbourg Court has rightly imposed some pretty clear rules with a view to ensuring a degree of clarity and consistency in this area, and notes that it should be followed. There's then a discussion, which I don't think I need to go into, paragraphs 93 through 97, about the tension between McCaughey and McCare. Again, the court recognising that there was at least potentially a divergence of view in the Supreme Court on these points. And noting at paragraph 97, the tension in particular between McCaughey and McCare. McCare, a 5-judge court whose ratio was clear and simple to apply, and McCaughey, which applied Strasbourg jurisprudence, criticised for lack of clarity, but which allowed domestic and Strasbourg jurisprudence to march together. Lord Kerr also addresses the genuine connection test at paragraph 203 and following of the same judgment. That's page 890 in the electronic bundle. Paragraph 208, he refers to the detachable duty to investigate and notes that emerges from the Slovenian case. Halfway down that paragraph, he notes that on one view, these are no more than arbitrarily selected standards, which might rather than must inform consideration of whether member states be required to conduct an Article 2 compliant inquiry into a death which occurred before the court required formal temporal jurisdiction. There is no inescapable point of principle, for instance, which requires the adoption of a 10-year period as the absolute limit on the period between the death and the critical date. So he too had the 10-year rule directly.
Is this a minority judgment, or I mean, did Lord Neuberger have a majority agreeing with him, or
he did,
what's
yes.
The situation?
Lord Neuberger had a majority agreeing with him. It's difficult to formulate exactly where this sits. If one reads the head note in the All England reports, it appears to cite Lord Kerr's paragraphs in support of Lord Neuberger's analysis. Mm-hmm. But certainly the majority of the court applied the 10-year analysis. And Lord Kerr looked at it quite closely. If you see paragraph 238, that's page 897. Here he's discussing the critical date, whether it's 1953 or 1966, but also with reference to Janovich. And you'll see the sentence Second substantive sentence, as the European courts made clear in, among other cases, Janovic, there must be relevant acts or omissions after the critical date and the period between the triggering event, and this is a quotation from Janovic, the period between the triggering event and the critical date must remain reasonably short, and then in square brackets, and while there is no absolute limit on the duration of that period, it should not exceed 10 years. That's a reference to paragraph 146 in Janovic.
Yeah. Lord Neuberger makes it clear at paragraph 90 that Lord Kerr's reasoning is different from his own.
Yes.
And therefore different from the majority.
The value, I think, in considering Lord Kerr's judgment in KU on this point is, again, it relates to how it's then applied in Finucane. And you'll see paragraph 146 is cited with a parenthetical insertion by Lord Kerr, which is an abridgment of what paragraph 146 actually says. It alters, in one sense, what it means.
Yeah.
I'm sorry, which page are you on? Just
898.
Page top of 898.
Thank you.
The insertion is that while there was no absolute limit,
Yes, thank you.
which is abrades to a degree with the actual meaning of 146, which is that there is an absolute limit,
Yeah.
and it's 10 years, subject to exceptional circumstances.
Yes. So he has that meaning the opposite of what he actually
Yes.
says.
Exactly.
Yeah.
He returns to it in the section under the heading, should the Human Rights Act be coterminous with the temporal jurisdiction of the Convention? That's at page electronic 900. And again, this section of the judgment is also of interest. Lord Kerr notes at paragraph 253 the need for legal certainty, which prompted the European Court's decision about the limits and the backward reach of the Convention. It refers again to Janovic, paragraph 133, and recognises at 255, page 901, the need for a connection between the triggering event and the duty to investigate. Otherwise, the backward reach of the Human Rights Act would be potentially limitless, or as it was put in Janovic, open-ended. Should the limit be, as the European Court jurisprudence, a short period and no longer than 10 years? That's a obviously correct exposition of what the Strasbourg jurisprudence was saying. He also observes in the same paragraph, sentence beginning, but to extend the duty backwards without any limit, simply because an adequate investigation is not yet been undertaken, would be significantly out of step with the Strasbourg approach. It would also, in very many instances, be wholly impractical. However unsatisfactory it may be in terms of principle, a limit must be set which is essentially arbitrary, but which accords with what is, in most cases, practically possible. It may well be the 10-year period chosen by Strasbourg is as good as any. Again, a recognition that I think all observers recognise there are arbitrary limits in play here. The limit, however, that's been selected by the Strasbourg Court appears to be recognised by the Supreme Court here in KU as being a 10-year limit. There are some nuances in the analysis, but it seems, we say, on a fair reading of this judgment, that that's the position the Supreme Court had come to in KU. That brings us to the decision of the Supreme Court in the Finucane appeal, which you'll have as the first in the authorities bundle, 644 is the page number. Now, the appeal here, obviously had been heard in the High Court and by the Northern Ireland Court of Appeal, was not a case involving an allegation of a frank breach of the Article 2 procedural obligation. Again, that may be of some importance in the overall analysis. This appeal proceeded on the basis of a legitimate expectation argument, albeit with Article 2 issues supporting the contention that it was unlawful to breach that legitimate expectation. But it's not a case squarely about the reach of Article 2 or squarely about the genuine connection. And that's clear from looking at the lower judgments, and it's also clear from Lord Kerr's judgment in this case, paragraph 53, for example, page 662, notes that the Article 2 breach was not advanced as a freestanding argument for the declaration, and it's also clear from paragraphs 151 to 152 of the judgment that this was not a ground of challenge in the actual appeal itself or the judicial review proceedings. That's clear from 151, 152, electronic page 680. I'll come back to that. So this appeal advanced primarily as a legitimate expectation appeal. That was the focus of argument. It's also the focus of much of the analysis. And you'll see from paragraphs 55 through to 82, the court deals with the legitimate expectation point. The Article 2 issue is dealt with from page 668. And you'll see here, paragraph 84 refers to the details, the factual details of that case. It's a death that occurred 11 years and 8 months before the Act was commenced. Refers to the question of whether or not an action be maintained even though the Act wasn't in force, and turns to consider the case law, some of which I've sketched for the court today already. I won't go through each paragraph of this analysis, but you'll see Lord Kerr deals with Kerr judgment, deals with Brecknell at paragraph 89, McCaughey at paragraph 90, deals with Silage in Slovenia, paragraph 94, and its application in McCaughey at paragraph 98. The discussion of the Janovich clarification is limited in this judgment. The court picks it up and looks at it closely from paragraph 101, that's page 671. You'll see how this issue is addressed by the court. So you'll have seen in the preceding paragraphs a quite extensive discussion of the silage test. 101, Lord Kerr notes that the observations of McCaughey must be viewed in light of the later decision in Janovich. In that case, the respondent claimed the Grand Chamber identified 3 limitations in the jurisdiction to examine pre-ratification claims. So then sets those out. The first is in respect to the steps taken. The second limitation, paragraph 103, respondent claims is a need for a genuine connection, and it's primarily a temporal one. And then quotes paragraph 146 of Janovich. Paragraph 104, again, records the respondent's argument on that and sets out 147, 148 of Janovich. And then the convention values test are set out at paragraph 105. Then the court moves straight to the conclusion. After 106, which is a statement of the respondent's case, which we say is, again, an accurate statement of the principle, the court concludes at 107 that the genuine connection has been established between the triggering event and the critical date in this case. So with relatively limited engagement with the Janovich clarification, the court reaches the conclusion that the genuine connection test has been made. The reasoning that follows, we say, requires to be considered closely. The court identifies 2 Strasbourg decisions, the case of Mokanu and Mladenovich. And in our submission, neither is supportive of the analysis that's ultimately adopted. The case of McCannu, you'll find at page 1471 in the electronic bundle. This is a Romanian case, one of a number from Romania in that period. The revolutionary demonstrations in Romania occurred in 1990. There were state actions that resulted in the deaths of protesters in response, and litigation commenced about that. But Romania did not ratify the convention and bring it into force until 1994. So there's a temporal problem in the Romanian cases, and there's a 4-year gap between ratification and the incidents in question. But the McCannu decision deals with the genuine connection point at paragraph 205, which you will find at electronic page 1503. And the passage relied upon by the court in Finucane by Lord Kerr is the paragraph in 206. When you read it in full, you'll see that paragraph 205 is a reference to Janovich, and it sets out the Janovich clarifications on the temporal limitations previously defined in Cilich. And then it says, it found in essence, and proceeds to paraphrase what the Strasbourg Grand Chamber had found in Janovich. And the sentence that's the subject of focus by Lord Kerr is in the middle of that paragraph, where it says, added that such connection was primarily defined by the temporal proximity between the triggering event and the critical date, which could be separated only by a reasonably short lapse of time that should not normally exceed 10 years. And the word normally is highlighted in italics in the judgment in Finucane at 107. There's a footnote to that. You'll see footnote 23. Footnote 23 highlights paragraph 146 of Janovich. So this isn't, in our submission, a gloss or modification, an expansion or dilution of the temporal requirement. It's an application of it. And too much weight has been placed on the use of the word normally in the paraphrasing passage in paragraph 206. So McCannu, we say, is not supportive of the conclusion that's reached. Mladenovich in Serbia is found at 1547 of the electronic bundle. This is a 2012 decision. So this is a decision which predates Janovich. And it is right, as the court observes, that there was a 13-year gap between incident and ratification. That's correct. But the analysis in this case, which is brief, from paragraphs 36 through to 39, page 1551 to 1552, it's clear, certainly from 1552, paragraphs 38 and 39, this is a straightforward application of the Cilich criteria. So the uncertain criteria which the Grand Chamber had to clarify. And before the temporal limit had been put forward in 2014. So Mladenovich and Serbia, we say, also provides no support for the conclusion that's reached. We then look at paragraph 108 of the judgment. Again, this requires close consideration.
Is this back in?
Sorry, back in Finucane. Sorry, maybe. Page 673. A period of 10 years or less between the triggering event and the critical date the coming into force of the Human Rights Act is not an immutable requirement. You'll see that phrase emerges again in the later Northern Ireland Court of Appeal judgments. The time which elapsed between the two dates is a factor of importance, but when taken into account with the circumstances, the vast bulk of noteworthy inquiry into his death was taking place since the HRA came into force, the significance of the time lapse diminishes. Now, there are at least two problems with that sentence. Firstly, the Grand Chamber clearly said in Janovich that time was the first and most crucial indicator, not just a factor, the first and most crucial indicator. Secondly, and perhaps more importantly, the Grand Chamber considered that the extent to which there had been inquiry after the critical date was a separate condition and involved a separate analytical exercise. What this sentence does is it elides the two together and suggests this is a composite multifactorial analysis rather than a staged question with two conditions, each one of which must separately be met. The third sentence of paragraph 108 states, nothing in Janovich detracts from the proposition in Silich. The decision as to whether there's a genuine connection involves a multifactorial exercise, and the weight to be attached to each factor will vary according to the circumstances of the case. In our submission, that's difficult to align with the clarificatory nature of the Janovich judgment, which was intended to restore the certainty that had been lost and had been identified by the court itself in Judge Lawrence's concurring judgment. So we say that sentence again is problematic because there's much in Janovich which modifies the analysis in Silich. The court then, at paragraph 109, goes on to look at the judgment in McCaughey. I've mentioned McCaughey already. It's a 2011 decision which imported the Silich and Slovenia analysis into domestic law on the basis that it could be inferred that Parliament intended retrospectivity to be qualified by later things the Strasbourg court did. Lord Kerr says, moreover, in McCaughey, it was made clear that an inflexible 10-year limit was not essential, and the consideration that most of the investigation took place after the critical date could compensate for the length of the time lapse. Refers to paragraphs 118, 119, and paragraph 139. It should be clear that at the time McCaughey was heard, there was no 10-year time limit. Janovich had not yet been promulgated. No one was discussing 10 years. It wasn't a feature in that judgment. Lord Kerr refers to paragraphs 118 and 119. Those are the paragraphs of his judgment, which do refer to 10 years, but coincidentally, in the sense that the case in question was a 1990 case. It was a 10-year period in play in that case. It wasn't being discussed as a normative statement or a statement of any principle. Paragraph 109 also refers to paragraph 139 of McCaughey and quotes Lord Dyson. What we say here is, again, there's no flaw in Lord Dyson's analysis here of what Silich and Slovenia meant. What he's doing is recording and paraphrasing the law as it stood in 2011, before we had the clarifications, pre-Janovich. So this is a pre-Janovich analysis by Lord Dyson. We say that provides no support either for the conclusion that's reached in paragraph 107. At the bottom of that paragraph, Lord Kerr records that significantly the court had not been invited to depart from McCaughey. That's unsurprising. There's no reason to depart from McCaughey. McCaughey was saying nothing about the issue in question. Everything that had been said about that issue was said in Janovich and the later decisions. So the fact that there was no departure requested was, we say, of no particular consequence. Paragraph 111, there's discussion of KU, some discussion of the debate between the different justices in that case. And then the final sentence is that the plain and inescapable fact is that this court in McCaughey unequivocally adopted the decision in Sillage as indicating the principal approach in domestic law to the question of genuine connection. That's not contested, but it doesn't end there. Obviously, there is the later approach that arises from Janovich to be considered. The court said nothing more about convention values at 113, and nothing more is said of substance of the genuine connection in that case. See if I've drawn your attention already to paragraphs 151 and 152, page 680, where the court was making observations about the extent to which the issue was before it. This may have some importance for how this court evaluates the submissions I anticipate the respondent will make. So paragraph 151 notes that in the High Court there had been a declined invitation to amend the application to plead as a freestanding issue a breach of Article 2. But Lord Kerr says before the court it was argued that the failure of the state to hold an Article 2 inquiry meant the government was required to adhere to its promise, so that was part of the legitimate expectation argument. 152, it appears to me in any event that we as the Supreme Court cannot ignore the question. And he proceeds then to explain why it has to be dealt with. And you'll see at 153, the court makes a declaration there has not been an Article 2 compliant inquiry. So that is the conclusion the court reaches. The question is whether or not the jurisprudence, analysed fully, properly supports the conclusion reached. And in our submission, it does not. However, this decision was of particular importance in the subsequent appellate jurisprudence in Northern Ireland. And indeed, in this case, the case is back before your Lordships and my ladies for consideration today. And that requires consideration of this question. How did and to what extent did the judgment in the Finucane case influence the Northern Ireland Court of Appeal in McQuillan, which this court went on to hear? And it's worth diverting here to the judgment of the Northern Ireland Court of Appeal in the McQuillan case. You'll find that that's 916 of the bundle. So as I've said, this case was heard before the judgment in Finucane had issued. The Northern Ireland Court of Appeal then promulgated its judgment on the 19th of March 2019. Lord Chief Justice sat, Lord Stevens and Sir Paul Girvan were the panel in the court, and the court dealt with the application of Article 2 in Part 5 of its judgment. This is page 944. Paragraphs 128 on, headings application of Article 2 EHR. First point to note is, we say here, wrongly, the Court of Appeal approached it on the basis of Brecknell first. So it addressed the Brecknell point first, when in fact the Brecknell point is a subsidiary component question within the genuine connection test. So you see paragraphs 108 and 129, discussion of Brecknell. Paragraph 130, court saying the first issue as the application is straightforward and goes into a discussion of Brecknell. Then at paragraph 131, there's discussion of Finucane, and you'll see that some of the passages that I've referred to are recited here. Paragraph 111, the inescapable fact is the principled approach in Sillage. Nothing in Janovich detracts from that, as said. Paragraph 131 quotes that. And then 132 discusses the multifactorial exercise to be adopted, and a discussion of what the lapse of time means in this context. And you'll see at the bottom of that paragraph the Court of Appeal's consideration, we consider, as a matter of principle, that generally it should carry little, if any, weight, given the passage of time as accommodated in the Brecknell case when determining the nature of the Article 2 obligation. Then, at 133, further consideration of the Finucane paragraph 108, quoting the guidance that a reasonably short lapse of time should not normally exceed 10 years, but permits of a longer period. We consider that whilst a genuine connection to be met on the basis of time, the length of time is not the only factor to be considered and weighed. Again, you'll see what we've said about Janovich on that. And then reference to 163 of Silich being endorsed by Lord Kerr and Finucane. And then 135, emphasising again, we've indicated as a matter of general principle, we consider that little, if any, weight should be attached to the passage of time in a Brecknell case, and then considers some further features. That analysis by the Northern Ireland Court of Appeal follows from the Finucane analysis outlined by Lord Kerr, and this court found to be wrong in McQuillan. The notion that the passage of time attracts little weight in a Brecknell case has been rejected by this court. You'll note also fairly limited consideration of the Janovich principles there. The Court of Appeal, perhaps unsurprisingly, took the shorter route of referring to how it had been analysed in Finucane and took that as its baseline starting point. The Court of Appeal gave leave to appeal to the Supreme Court of McQuillan in December 2019. It refused leave in the McGuigan case, hooded men, although this court later granted leave or permission, and both were heard together in June 2021. The next question for our consideration is, what has the impact been of the reasoning in Finucane and McQuillan on this case, the Dalton case that's before the court for consideration? And if you take up the, well, you don't have the core volume, but the Court of Appeal judgment can be found at electronic page 165. The court will have our point by this stage if there's an error in the analysis in the Finucane case, and if that error translates into McQuillan, which it did, then one's looking to see if the same error features in the Dalton analysis. Page 165, the Court of Appeal is composed of the Lord Chief Justice, Lord Stevens, and Mr. Justice Maguire. The judgment's given by Mr. Justice Maguire, and this is given in April 2020. By this stage, this Court of Appeal, well, two of the members of the Court of Appeal had already given leave to go to the Supreme Court in McQuillan. And on one view, had we waited for the court to rule in McQuillan, then we may not have had to bring this appeal, because we say, in one view, McQuillan answers this case. The appeal should be allowed. It didn't do that. It went ahead and promulgated the judgment, and you'll see at page 179 a discussion of recent case law, paragraph 76, and paragraph 78. Mr. Maguire notes correctly that this has produced its fair share of litigation in recent times in the Strasbourg Court, the domestic court. However, there's been increasing clarity as to how to approach this issue. The court doesn't seek to describe the twists and turns en route to where the law stands now. They've been discussed elsewhere. Footnote takes you back to the Finucane judgment and sets out to describe the position that's been reached, focusing on three decisions: Brecknell, 2007, the judgment in Finucane, 2019, and McGuigan, 2019, although we also had McQuillan in the mix at this stage. You'll see then, and I'm not going to go through these paragraphs, but paragraph 80 onwards is analysis of Brecknell. Again, the same flawed approach of addressing Brecknell first, rather than addressing the genuine connection first. Then from paragraph 84, discussion of the Supreme Court decision in the Finucane case. Paragraph 88, it's noted that that's generally of assistance in the present case. And there's a digest there in some Roman numeral paragraphs of what the Supreme Court had found. The doctrine of revival is discussed, page 189 onwards, and that's the Brecknell type analysis. So again, we say this is the wrong approach, going to Brecknell first, rather than first of all determining whether the genuine connection test is met. So the court deals with the issue of revival, concludes that there has been a Brecknell type revival. You see that at paragraph 114. Then says at 115, this leaves, however, the question of whether in 2005 it could be said that under the genuine connection or convention values test, as they've now been explained, it had been satisfied. And there's a reference there to various open questions that remained. Court then says, while it's right to acknowledge that in this case some 12 years had passed from the date of the deceased's death to the critical date, as this court indicated in the Hood and Men case, the 10-year time limit set forth in Janovich should not be viewed inflexibly. In Finucane, the Supreme Court viewed this aspect as part of a multifactorial exercise, which depends on a view taken as to the weight to be attached to the various relevant factors. And then quotes McQuillan, which of course by this stage is in travel to this court on appeal. Quotes McQuillan, relies upon that to say, in that case, last sentence, the court went so far as to say that as a matter of general principle, we consider that little if any weight should be attached to the passage of time in a Brecknell case. That's decisive. The court then says, 116, in light of these factors, they incline to view the genuine connection test on the facts of the present case is satisfied. And then there's an observation that convention values is unlikely to be met. It's an uphill struggle. So that analysis, by paradigm reasoning, is the same analysis this court considered in McQuillan. I'll show you that shortly, and found to be flawed. And that's the analysis that led the court to find the genuine connection test had been met in this case. So, McQuillan, the decision of the 7-judge panel in this court, makes it clear that this is the wrong approach. And then turn to the Supreme Court's decision in the conjoined appeals of McQuillan and Hooded Men. You'll find that in the electronic bundle at 683. Two appeals in play here, both raising questions of genuine connection and a number of other ancillary questions about what it means if Article 2 is engaged, i.e. police independence, so on and so forth. But the court is addressing directly the question of the application of genuine connection in the McQuillan appeal. And if you have a reference point for that is paragraph 62. The court can see page 702 what was in play. I don't need to go to that, but you'll see it's a direct question about the application of the genuine connection test in a 28-year gap case, as that one was. The judgment on the procedural obligation, or the part of the judgment that deals with the procedural obligation, is found at paragraphs 109 and following. You'll find that at page 718. And the genuine connection analysis is found at page 726. That's paragraph 133. The court here sets out in extenso the Janovich analysis, page 728, paragraph 137. You'll see just by letter H on page 728 a reference to the footnote within Janovich, which is the footnote to Brecknell. again, locating Bracknell as a subsidiary issue. And then a clear, again, recitation of paragraphs 146 to 148 of Janovich, including the 10-year normative statement. There's discussion of the approach taken in the Finucane case at paragraphs 143 through to 144.
Just one point that's slightly troubling me. Your point about one takes the genuine connection issue before Bracknell. My recollection is that's not how we reasoned it in this case in McQuillan.
No, it's not. Well, that's correct as a statement of how it was done, I think.
Right.
I'm suggesting that...
But you're not pointing out that in that case we've also adopted what you've so far argued was the wrong approach.
I think it's not done in the same stark way of a focus on Bracknell than genuine connection. In this case, in McQuillan, the court deals with the genuine connection point squarely as a freestanding and separate issue.
Sure, but it was after looking at Bracknell.
Well, it's might be worthy of looking at considering again what the correct approach should be. But
the implication of the last sentence of paragraph 146 of Janovich appears to be that Bracknell only arises in a case where the period exceeds 10 years if the convention values test is satisfied.
Yes. So temporal first, if not temporal, convention values. If convention values, then Bracknell.
I think on Lord Burroughs' point, paragraph 178 of the judgment in McQuillan, we say that the Court of Appeal went wrong by treating the genuine connection test as subject to Bracknell, whereas in fact it's the other way round.
So there's no flaw ultimately in the analysis in this judgment on that approach. But our submission is that's doctrinally the correct approach. And what happened in each of the Northern Ireland Court of Appeal decisions, they got that wrong, including this one.
I don't think that matters what order you deal with the issue. You might decide that there be no obligation, Bracknell doesn't apply, so you don't need to consider genuine connection, for example. What surely matters is that the Bracknell test is subject to the time limit. I mean, the Bracknell, you can't have a revival which is not subject to the time limit.
Well, I suppose it matters in the sense that, like in a lot of these cases, you'll see in the Court of Appeal in Northern Ireland, the focus has been deep analytical focus on Bracknell. Unnecessary deep analytical focus, because had you first turned to the temporal question, there was never any need to get into that. Mm-hmm. So it colours potentially the analysis if you're looking at the Bracknell issue. And I think that, perhaps viewed objectively, is the problem the Court of Appeal fell into in McQuillan and indeed in this case.
But what is the Bracknell question that the court has to ask once it's decided that the genuine connection test has been met?
If the genuine connection test has been met, then we have Article 2 in play at that juncture.
Yes.
And the Bracknell question is whether or not there's any new or additional information leading to identifying a perpetrator that would warrant a contention that there'd been a breach of the Article 2 obligation.
Yeah. When genuine connection goes to jurisdiction.
Yes. Bracknell goes to the substantive analysis of the article. So I was going to take the court to the paragraphs 143 and 144 of the McQuillan judgment, which is the discussion on the Finucane analysis. I'm not going to read 143, 144. The panel in McQuillan is raising a question about whether or not there had been any clear articulation of principle in the Finucane judgment that would lead to as it was put here, a watering down of the strict 10-year requirement, which appeared to have been laid down in Janovich. And our submission here is when you analyse that judgment, analyse the substrata of jurisprudence that's relied upon, there isn't a clear principle. We're left with uncertainty. And uncertainty with genuine practical problems in application. Practical problems for courts, practical problems for coroners, for the attorney who's asked to open cases, and reaches for legal principle, which is, we say, of no utility. Practical problems for the Chief Constable, who has to prioritise investigations into 1,000 historical cases. And one of the claims that's frequently made is you must prioritise the Article 2 engaged cases. Well, how do you do that for the 1988 to 1990 cases? You have to conduct a genuine connection analysis. That's achievable if you have a bright line temporal rule. But if you have to conduct a multifactorial analysis of the type suggested by the court in Finucane, it's unworkable. It generates uncertainty, generates litigation, generates frustration for the next of kin who embark on lengthy litigation not knowing what the outcomes will be because the law is not clear. So it is important, we say, that there's a clear principle in play if we are to move away from the 10-year limit outlined in Janovich.
So, as I see it, the difference, I think, between you and the Finucane analysis, it comes down to the multifactorial aspect of Lord Kerr's reasoning. Does that mean, say, in a case where there was an issue about, say, obstruction of the investigation that the state is obliged to undertake in an Article 2 environment, that those facts wouldn't come into account if the temporal limit was set at 10 years?
Yes.
It does?
It means there is a clear cut-off point. A temporal limit applies. The only question we ask is whether or not that obstruction that's being described, if it's evidenced, is it sufficient to give rise to a convention values type problem?
Right.
If it is, then there's the scope for exceptional extension. Whether it would or not, that's a hypothetical question, but that, if you're following Janovich and trying to find a clear path, that's the analytical approach that has to be taken.
So the only exception to the 10-year limit is the convention values test?
Yeah, and that was the Strasbourg Court trying to provide a rule that would ensure legal certainty.
Yes. And legal certainty, again, we shouldn't lose sight of the fact, this court won't lose sight of the fact, legal certainty is a fundamental convention norm. I mean, this court will be asked to condemn legislation that doesn't achieve legal certainty, or condemn administrative action based on policy that doesn't achieve legal certainty. Yet, it's applying, in the guise of a convention norm, something that is inherently uncertain. Therein lies the problem, and the root isn't necessarily the judgment in Finucane. The root is taken right back through Janovich, Silich, and detachability. What's the role of this court? The role of this court under the Human Rights Act is to give effect to the Strasbourg jurisprudence as best it can. And Janovich, we say, provides a clear articulation of the rule. The next part of paragraph 144 is, in our submission, still problematic. I've articulated, in response to the Lady Chief Justice's question, what I say to be the appropriate norm. The appropriate norm is temporal rule, 10 years, plus exception for convention values cases. This court, in the latter part of 144, recognises scope for a 2-year extension to that. Now, what's the principled basis for the 2-year extension? Lord Kerr recognised, as have many others looking at this, that these limits are arbitrary. So we've had an arbitrary 10-year limit endorsed by the court in Janovich. It's got a certain degree of workability. What is, I ask rhetorically, the basis for the 2-year? extension. And there isn't a principled basis for it, save for the fact that 2 years captures the time period that the Supreme Court have already considered to meet the genuine connection in Finucane. There's a circularity to the analysis. The better approach analytically in our submission is to adopt the Janovich standard, not the 12-year standard.
So I think in McQuillan, as is recorded here, there wasn't any argument that Finucane had been wrongly decided in relation to the genuine connection. And in a sense, paragraph 144 is trying to accommodate that position.
Yes.
But am I understanding correctly that you are now inviting us to depart from Finucane to that extent?
I think the court, if we're asking for legal certainty, as the attorney is, who has to apply these norms, we're asking the court to apply Janovich and to apply that. If that involves a departure from Finucane, then that's a principal departure.
Lord Curran made it absolutely clear he was following Sillage.
Yes.
And he wasn't applying the last sentence of paragraph 146 of Janovich.
Yes. So the court in McQuillan didn't need to grapple with the issue in the same way because those were both cases from 1971 and 1972. So the issue wasn't sharply in focus there. It is sharply in focus here, was sharply in focus in the Finucane case, and will be sharply in focus in dozens of others, potentially. Cases of death or injury, as Article 3 is in play, in the period between 1988 and 1990. The question will be, is the genuine connection test met? And what's needed, we say, is a readily measurable standard. The court in McQuillan went on to consider the question of the impact of new information or Brecknell type information, paragraphs 157 and following. Again, an important section of the judgment, page 736.
Just before we leave the crucial paragraph 144,
yes,
your need for legal certainty is, in any event, covered, isn't it, by that paragraph? Because the exception for up to 2 years is tightly constrained. It's an extension up to 2 years in particular circumstances.
But it's temporally constrained, so we know it's a 2-year outer limit. There's no articulation of what the circumstances are. Are the circumstances to be confined only to convention values in line with Janovich? If so, then yes, potentially there's legal certainty. If it's not to be so confined, then again we have the same type of difficulty. So there's
sorry, A and B has set out the precise circumstances.
And surely what's being talked about there is the genuine connection test, not the convention values tests. Earlier in the judgments, the two are clearly differentiated.
Yes.
It also, as well, Dr. McGleenan refers there to compelling reasons in relation to inadequacies with the original investigation and then the investigative efforts subsequently. So is that not clear?
Well, all of that gives rise to further evaluative qualitative judgments. It's clear in its articulation of what it means, but in its application, it again gives rise to considerable scope for dispute. So,
yes, in a present case, for example, was the original investigation the one by the police back in 1980, 88, 89, or is it the one by the Ombudsman more recently? And then depending on how you want, that's question A. Well, no, sorry, that's question B I'm looking at.
Yep.
Well, A asks, any original investigation could be seen to have been seriously deficient. Now, is that the police investigation or the Ombudsman investigation? And under B, the bulk of such investigative effort postdates the critical date.
Well, that gives rise.
How does one answer that on the facts of the present case?
That also bleeds into the other question about how are we making this evaluative judgment in terms of deficiency. If we're talking about the Article 2 obligation, the Article 2 obligation is to seek to identify perpetrators in respect of the crime. The issue in this case is not about identifying the perpetrators of the crime. That's not the issue. The issue is about the potentially negligent conduct of the police in the management of the scene and the out-of-bounds area. Now, is that...
That's a separate argument.
Yes, it is a separate... Yes, but that separate argument is folded into the consideration of A and B, necessarily. We have to decide what it is we're judging here in terms of the quality of the investigative effort. Is it
if you're wrong about the separate argument, what would your position be on paragraph 144?
The position would remain that the A and B criteria retain a residual degree of uncertainty.
The B criterion seems to be going back to what you were criticising in Lord Kerr's judgment in Finucane of mixing the second condition in the genuine connection test as to when the bulk of the investigation had taken place or should have taken place in with the first condition of the purely temporal limit in a way which I think you said was unhelpful as it was done in Finucane.
Well, what is helpful in Janovich is the clear delineation between the temporal standard and the bulk of the investigative standard. Those are separate questions.
Yes.
And Finucane...
There's also a problem around whether it has taken place or has or ought to have taken place, as it said in Janovich. I mean, it's arbitrary, really. If it has taken place, it might be said, well, that's exactly what we're complaining about, that it ought to have taken place, but it hasn't.
Well, that's a particularly problematic concept.
So the fact that there has been investigation seems not a very entirely satisfactory requirement on its own as to why that should open the door when a failure to carry out a proper investigation doesn't.
Mm-hmm. I'm struggling a little bit just to follow this submission because it's clear from Janovich itself, paragraph 147, that there are two conditions which have to be satisfied for the genuine connection test. One is a pure temporal condition, 10 years, no more. But even within that 10-year period, you get these much less clear criteria, which also have to be satisfied as to when the investigation was carried out or ought to have been carried out. So I'm not sure that that aspect of paragraph 144 of McQuillan is introducing uncertainty that isn't inherent in already.
Yes.
I mean, I can see that you can say, well, you've extended the time period within which that uncertainty may have to be resolved from 10 years to 12 years. Yeah. But I'm not sure that it's introducing something that wasn't already in Janovich itself.
I'd be inclined to agree with that. I think the doctrinal problem, the roots of the doctrinal problem aren't in the Supreme Court decisions. They are in the Strasbourg jurisprudence, ultimately right back to the original articulation of the genuine connection test. That introduced these concepts, which the clarification in Janovich only does so much to resolve. They remain in place. And our courts have, through McCaughey, patriated that into our own analysis. That's where the problem lies. And really what we're seeing here is the outworking of Lord Rogers' prediction that this is a hammer blow to certainty once you import these concepts. And we're wrestling now with the fine detail of that, but the source of it is the jurisprudence that began with Sillage.
I mean, I can certainly follow your submission that if you keep the two criteria in Janovich and McQuillan separate, you buy a very high degree of certainty temporarily if you go beyond the 10 or the 12 years. But you're always going to be, and you ought not to, you say you ought not to muddy that line by mixing it up with the second and wholly independent criterion identified in Janovich, which is harder to apply.
Yeah. It's very difficult to remedy that problem without going right back to McCaughey and saying, at the point when the court embraced in McCaughey this standard, we have woven into our analytical system something that is problematic. Now, for the purpose of this appeal, we don't have to go that far, of course, but if one had a clear table and we're looking for a doctrinally pure approach to this, then you would ask the question about whether or not it was correct to do what was done in McCaughey. Because that, as was forecast at the time, gave rise to these difficulties in legal certainty.
I think Lord Roger called it bringing uncertainty home.
Yes.
Can I be sure I'm following this? Obviously, I wasn't involved in the McQuillan case, so I'm less of a veteran of these affairs than some others. Janovich seems to lay down a simple test of temporal jurisdiction in paragraph 146. It's a 10-year time bar. It's subject to an exception where the convention values test applies. So that's it, 10 years unless convention values. At the moment, it looks to me as if McQuillan, in order to accommodate Finucane, which wasn't being challenged, has said that you can have an additional 2 years on top of the 10-year time bar, provided effectively the factual situation is analogous to Finucane, that there's the conditions A and B are met. Is that right?
That is right, but I think there's the problem is derived from Janovich itself, because Janovich, even the 10 years, let's say it's a case that's inside the 10 years, the second condition also has to be met. So it does require the analysis of the quality of the investigation. So it's still there.
Yes, genuine connection is necessary but not sufficient.
Yes, so that carries on.
But is the problem then that by referring in B here to what looks and sounds very similar to the ordinary second limb of the Janovich case, it's suggesting that has some additional import when one's looking at a period between 10 and 12 years, something over and above what it means when one's looking at a triggering event less than 10 years ago. And that it's not clear what additional role, if any, that second limb of the genuine connection test is playing in that extra 2-year period. That seems to me the difficulty.
Yes.
But as you correctly said, the problem is in Janovich, because if you look at 1677, you might get a very bright line test from paragraph 146. But if you go on to paragraph 147, the court then says the duration of the time period between the triggering event and the critical date is, however, not decisive in itself for determining the genuine connection test. And then we get into whether the investigation of the death took place or ought to have taken place in the period following the entry, which, with respect, is consistent with paragraph 144.
But in that event is are A and B, this is Lady Rose's point, A and B are part of the requirements for temporal jurisdiction in any event. And if that's right, then what's said about the 2 years in paragraph 144 of McQuillan is in reality turning a 10-year time bar into a 12-year time bar.
Yes. Yeah. That's what it's done. We have a 12-year time bar.
Yeah.
The effect of that is we are now reading back to 1988.
Yeah, because you have a 12-year time bar subject to the convention values exception. But you always also need to have the satisfaction of the test set out in 147 of Janovich, which is what A and B amount to.
Yes.
But that applies in every case.
Problem with this, I mean, part of the reason why we get to this analysis is the application of the mirror principle. That's how we got here in the first place, through McCaughey, mirroring what Strasbourg were doing. That was the contention that led the court, the 6 of the members of the court, to take that view in McCaughey.
Yes, although it's a bit of a distorting mirror.
Yes.
Because they talk about an analogy. I mean, if it were a mirror, you would be going back 10 years from the 1966 right of the petition.
Yes.
Which is what, obviously, if people, for example, if this case is lost on a question of time bar, that wouldn't be a problem in Strasbourg.
Well, that's a feature of this area of the law. That's right. And the case can go to Strasbourg. It's a problem. The mirror problem has a distorting problem, I think. There's a question of what are we actually reflecting here? And there's also a question of whether or not, in fact, if we have, through McQuillan, moved to a 12-year period, that's not reflecting what the Strasbourg jurisprudence says. That's getting ahead of the Strasbourg jurisprudence. And this court in A and B, I think, in decision given in July 2021, indicated how the ULA principle should be articulated and the limits of it. And here, on analysis, we're moving to a 12-year threshold, going beyond the boundaries of the Strasbourg jurisprudence. So on applying the mirror principle, 144 has a difficulty with it.
Well, yeah, they say up to a point, because this is effectively saying the time bar, you're time barred if your claim, in inverted commas, arose prior to the 3rd of October 1988, whereas Strasbourg would say you're time barred if it arose prior to whatever the date was in 1956.
Yes, different critical dates. I accept that. But of course, the argument's moving in circles now. If we're operating by analogy, we still use the temporal analogy of the 10-year time period.
Can I just be clear what you are asking us to do? So at one point in your submissions, you say you need to go back to McCaughey to unravel the problem. But McCaughey, I don't think you have asked for permission to revisit that, and indeed that was I think 7-justice panel.
Yes.
Anyway. So that point in the analysis we have to take as read, and you're not in fact challenging it despite your comment just then. As I understand it, you are inviting us to overrule Finucane.
Yes.
To the extent that you say Lord Kerr has mixed up the two criteria taken from Janovich, which ought not to be mixed up and should be applied separately. And to that extent, you're inviting this court to correct what it said in McQuillan and to align it back more precisely with what you say is the correct interpretation of Janovich. That's
correct. What we've said in our application, we've flagged the difficulty with the Finucane case. We've indicated that the court should depart from that. There's an issue about whether or not, or the extent to which that was actually key and open before the court of Finucane in any event, but that's what we're asking the court to do. The paragraph 144 of McQuillan is analysis that's consequential on the Finucane reasoning. So if the court accedes to the submission that Finucane was wrongly decided on that point, it follows that the consequential observations in paragraph 144 should also be revised.
So, and I think that you could say that actually wouldn't be to overrule the result in McQuillan, because that was concerned with deaths, as you say, happened many years before, so it didn't matter whether it was 10 years or 12 years.
Exactly. In that case. 28-year plus cases. It has no impact on the result of McQuillan at all. But stepping back and looking at it, the court, this McQuillan court, paragraphs 143 and 144, was clearly ruminating and reflecting on what is the correct approach post-Finucane? And it didn't have analysis on the point. This court has analysis now on the point, and if the court is persuaded by it, then it can modify the principle as articulated in paragraph 144.
And
in
does
the
this...
interest, sorry, Mark.
Sorry.
In the interest of legal certainty, we say.
Yeah. Is there any similar point in relation to Finucane? I mean, are you actually asking us to overrule the decision?
Yes.
Yes. I think you'd have to, wouldn't you?
Have to, yeah, the decision
Right.
in that
I
case.
thought you started off by saying it was primarily a case on legitimate expectation.
The outcome was a declaration that there had been a breach of Article 2. That was the decision. That's the ultimate outworkings of that decision. That's the order of the court.
But it was something like was it 11 years, 7 months, something like that.
11 years, 8 months.
Yeah.
Right. This case, we shouldn't pass by without observing that this case is a 12-year, 1-month case. So it's a case that, on any analysis, doesn't meet the genuine connection test. There's a straightforward approach in respect of that. But obviously this court has...
Can I just be clear about your reasoning as to what is unsatisfactory about leaving the position as it currently is in McQuillan in the final sentence? So when I first read that final sentence of McQuillan, I understood it to be saying that A and B there were the compelling reasons, or the potential compelling reasons, that would cause the court to go beyond the normal 10-year limit of up to an additional 2 years. But I think you're saying that actually A and B are reasons that apply anyway over the whole 10-year period because of the second limb of the genuine connection.
Yes, they're always in play.
So then either the 12-year period has replaced the 10-year period, for which there's no mirroring justification in the Strasbourg case law, or else it's not clear what additional factors need to be considered to stretch it over the next 2 years.
Yeah, it's certainly not clear why it's 2 years. There's no particular reason why it's 2 years.
I mean, in a sense, there was no particular reason why it was 10 years.
No, these are arbitrary limits.
Janovich. I mean, isn't it tolerably clear that in paragraphs 143 and 144 in McQuillan, the court has faced up to Janovich, has said that was 10 years. Ordinarily, mirroring would mean that it was 10 years for us as well. But Finucane has come along. You, who are arguing the case on the public authority side, we're not challenging Finucane in that case. And so the court, just as a matter of coping with its own jurisprudence as well as the Strasbourg jurisprudence, had to modify where the cutoff would be. And true, it's an arbitrary line 2 years later, but no more arbitrary than the 10, and it accommodates Finucane.
Well, it does that. It's a matter for this court. What one has then is a multiplicity of arbitrary lines. Again, I think that abrades with a workable concept of legal certainty.
Certainly. I mean, I follow that you're inviting us to overrule Finucane and say, let's go back to Janovich, 10 years, and McQuillan should be modified in the light of that being the correct approach. That's I follow.
Yes. I think those probably are the submissions we have to make in respect of that aspect of the case, the genuine connection point. As I've indicated, that it is the case that in a 12-year plus 1 month scenario, if the court continues to apply a 12-year temporal limit, this case doesn't achieve genuine connection and didn't at the appeal stage. So.
Sometimes that would be said, and therefore we ought not to be using this case. if we might otherwise be persuaded that Finucane was wrong, to correct Finucane, because the result in this case wouldn't then depend on whether Finucane was right or wrong. But I suppose you would say there are other cases stacked up within the system, and actually certainty does need to be achieved, and you say it's best achieved by going back to Janovich.
Otherwise, we'll begin a journey again with another case to come, another 1989, 1990 case to get to this point, to have the discussion again. So the court granted permission, obviously because it saw a larger dimension to this, and there is a larger dimension to it. We invite the court to take the approach we've outlined on genuine connection.
How would you apply paragraph 147 if you say paragraph 146 is 10 years subject to convention values, but that is not, according to paragraph 147, conclusive? One has to consider the paragraph 147 is used. How would you apply that? Because you were in effect asking us to focus on 146 and put a full stop after paragraph 146.
147 is very difficult to apply because it's inherent again in paragraph 163 of the Silage judgment. That thus second section invites us to engage in a kind of empirical analysis of what has been done and what ought to have been done, but which isn't, an imponderable question in many, many cases.
Yes, but that is, I mean, what it is saying in 147, as I understand it, is the 10-year limit isn't absolutely decisive. You have to go on to carry out this rather difficult exercise.
10-year limit is decisive if a case is outside 10 years. If it's inside 10 years, you have to conduct the second aspect of the exercise. So it's the temporal limit is clear for a plus.
I see, that's how you read it.
Yes. Mm-hmm. So, and that's...
Sorry, which second part of the exercise?
The exercise of examining what amount of investigation has taken place before the critical date, what's taken place after, what ought to have taken place but didn't take place. That, which is a very, very difficult standard to apply juridically, is the problem. But the more straightforward reading is to take the 146 temporal limit.
So there's a bright line after 10 years, but not a bright line before 10 years.
Precisely, yes.
Yeah, and I think you're inviting us to read where it says in 147, the temporal period is not decisive. That's because the claimant doesn't win just by showing that they're within the 10-year period. They have to satisfy some other things as well. And I think you've drawn our attention to paragraph 148, which it says both criteria must be satisfied if a claimant wants to bring a state within the jurisdiction of the court.
Yes, because we don't lose sight of the fact that all of this is an extension from the norm. The norm is you stop at the critical date. You're into an extension period with genuine connection. If the extension is less than 10 years, you still have to engage in this evaluative judgment of what's been done and what ought to have been done. And only then do you get through to the next stage of the analysis. That, in my submission, is a more coherent reading of what this means.
But you might say that what you're asking us then to do is to produce greater uncertainty, because as I read what is said in paragraph 144 of McQuillan, you don't look at that qualification until you're past 10 years, until you're in the 10 to 12 year scenario. You may say that's a wrong interpretation of Janovich, but
that's a bit difficult, because if you're applying Janovich, then you ought to be engaging in that qualitative analysis in your
within the 10
not 10-year cases, not just your 10 to 12-year cases. Yeah. So that's what the Grand Chamber is saying.
Yeah. I mean, Janovich is, the whole point of Janovich is to provide legal certainty by providing a clear time bar rule. And the time bar rule is if your claim is more than 10 years old, end of story. And it's unless you can establish a convention values issue. But if you're within the 10 years, then you have to do the work of satisfying the test set out in 147.
Yes, which is what happens in reality in post-1990 cases. They're in the High Court or in coronial cases. we're not shut out on time, but we have to go through the gears of assessing what has been done, what ought to be done, what wasn't done.
Yeah, 146 is simply concerned with what in Strasbourg they would call jurisdiction ratione temporis, a threshold jurisdictional question.
Yes.
And if I may, just on paragraph 144 of McQuillan, in response to what I understood Lord Burrows to be saying, I don't think that is saying a claimant only has to show that they're within 10 years and not satisfy the second criterion in Janovich. It's taken both limbs of Janovich as read, and it's just addressing if there is to be an extension, how do you do that? And in effect, it's replicating Janovich just with a 12-year cut-off and more or less the same conditions that have to be satisfied within that.
I hadn't read it as hollowing out Janovich.
No, absolutely, that's the point. It wasn't hollowing out.
Sub-10-year cases.
No.
Janovich still applies.
Yeah.
On that approach, then this is unproblematic.
So really the only problematical aspect of paragraph 144 of McQuillan on your approach is the additional 2 years.
2 years.
That's it.
And again,
which is, as I understand, wholly taken up with whether we depart from Finucane.
yes.
Exactly.
You have my submissions on the analysis of Finucane, the principles that upheld it. I don't need to repeat those. If those points are sound, the court can make of that what it will. But that, I think, covers that point.
Can I just clarify in relation to what you said about the evaluative exercise that's highlighted in Janovich and 144 of McQuillan?
Yes.
Are you saying that's because there would have to be an analysis as to whether or not another investigation is necessary, if you think about it?
Yeah.
So that's why that's there?
Yes. If it's, let's make it concrete, if it's a plus 1990 case,
Yeah.
deaths occurring in 1992, 93,
Yeah.
and there's an argument that there's a collusive dimension that wasn't properly investigated,
Yeah.
an evaluative judgment's got to be made by someone. It might be the police, the chief constable, it might be coroner
Or a
or the
coroner.
court, who's got to make an assessment of whether or not that's adequate or not. Now, there are problems with that, but that's not necessary for us today. That's where that gets you. In post-90 cases,
Yeah.
you have to go through that exercise. There are a diminishing number of those kinds of cases over time, but what this leaves us with is that problem in the period from 88 to 90.
But that evaluative analysis often happens in Northern Ireland due to difficulties with investigations that occurred at the earlier stages.
Yes.
I mean, that's not unusual.
No, it's not. I mean, it does happen, and indeed, it's something that's easier to grapple with the more recent cases than the ones that are further away. So there's again a principled reason not to unnecessarily extend a temporal period if the Strasbourg court is not mandating that.
The relationship between that exercise and a Brecknell type revival exercise is quite difficult conceptually, I think.
Yes. If we're in a case where it's post 1990, where there's a serious contention that things ought to have been done or weren't done correctly, then you may get the genuine connection. And then Brecknell, the issue is whether or not at that juncture there is a need for another investigation because the exercise we're embarked upon is likely to lead to the identification of perpetrators, rather than just some wider malaise in policing or some state involvement. So may still have to go through the Brecknell analysis. Can I come to that point, just the second topic? Obviously, if we're right on the first point, the second point doesn't necessarily come into play, but the issue here is confined really to the Court of Appeal's approach. In this case, and you have the judgment for you, 165 of the electronic bundle. Again, as I've already said, this is a case where the Northern Ireland Court of Appeal did this in McQuillan as well, focused on Bracknell first, conducted that analysis, and then went to genuine connection and concluded it was inside the temporal period. So there's a lengthy discussion of Bracknell from paragraph 80 onwards, that's page 180, sets out the key passages from Bracknell on page 181, paragraph 65 and following.
Just before we plunge into the detail of this, can I just check what your position would be? If we were with you on the first issue, engagement of Article 2, what do you invite us to do in relation to these other issues, which, as you pointed out, strictly as a matter of logic, don't arise if you're right on issue 1? But nonetheless, the Court of Appeal has gone into them. Do you invite us to go into them or to leave them?
I think I would invite the court to go into this issue, this question. It may not be necessary at all to go into the third question, or the quality of whether or not the Article 2 obligation is being discharged. I say it's worth going into this issue because there is a question here of some importance, which is whether Bracknell, as a reviving concept, is confined to information about the perpetrators of the crime, or whether it's a more expansive concept that involves wider considerations of the quality of investigations.
Yes, thank you.
Because if it's confined to perpetrators of crime, that's, we say, the source of this in Bracknell. That's a more manageable concept than generalised complaint about the quality of investigation, about which there will be great scope, no doubt.
Well, it's not really about the quality of the investigation. It's about the involvement of the state in the events that occurred.
Yes, it can be that, I agree. Maybe I've compressed the point too early.
Well, the concern here is not the quality of the investigation. It's whether the police ought to have alerted.
Yes.
The neighbours.
Whether or not something more could have been done.
Yes.
In order to draw attention to it. Yes.
Leading up to the incident itself.
In circumstances where that something more could never lead to any further progression in identifying the perpetrators, because that concept has reached the end of the road. This exercise is only about looking at whether or not something more could have been done to protect the lives of those who were tragically killed.
But is that not within Article 2's compass, accountability of the state for actions related to the death of someone?
Generally speaking, yes. There's authority to that effect. Our friend will rely on Honour Yildiz in Turkey, other such cases. As a general proposition, yes, but if we're looking at a revival doctrine, in other words, bringing back into play an Article 2 obligation which is dormant or non-existent, then it must be something more than simply a general obligation to protect the right to life. It's something that leads to, as Bracknell says, the identification of perpetrators.
Yes, but you're recognising the wider role of Article 2 in relation to the activities of the state. But you were saying that on a proper construction, Bracknell is confined to the identification of the perpetrators of the death.
Yes.
The Article 2 investigative obligation is certainly not confined to situations where the state may have had an involvement in the death.
No.
I mean, the commonest way of, well, one common way of fulfilling Article 2 obligation is through criminal trials.
Yes. Again.
No, and I don't mean criminal trials of police officers or soldiers, but criminal trials of people who assault other people.
Yes. Well.
Generally.
We don't dispute that. Trying to focus on Bracknell as a revival doctrine. So if we have a dormant, non-existent Article 2 obligation, what is it that gets you back into the Article 2 analysis again? And the approach generally from Brecknell has been, and you can take it from the judgment, page 183 in the electronic bundle, paragraph 71. The court takes the view where there's a plausible or credible allegation, piece of evidence or item of information relevant to the identification, eventual prosecution or punishment of the perpetrator of an unlawful killing, the authorities are under an obligation to take further investigative measures. So it's something in that paradigm that gives rise to the obligation to conduct a further investigative process. Now, in this case, the next of kin are understandably concerned that more could have been done in terms of protecting the area, alerting people to possible danger, and there's a pleaded case in negligence to that effect. But that's not the paradigm which Brecknell is operating in. Brecknell is confined to this scenario. Now, that, we say, is a principled approach that has been applied generally.
How would that apply in a more traditional or typical Article 2 case of, say, someone who is murdered in prison by another prisoner, and there's the question of whether the prison guards could have prevented it. Then later material emerges as to what the prison guards knew about the risks of friction between these two prisoners. Would you say that was inside or outside the Brecknell test?
Well, those types of death in custody cases are a freestanding group in a sense that it's already accepted. I mean, in our ordinary coronial law, there's an obligation to have an inquest in respect of a death in custody case because of the nature and the vulnerability of those who are detained. So they're in a different category.
Yes, suppose there had been an inquest and it had decided that there was no fault to be attributed to the prison authorities.
Yes.
But then later, information emerges that suggests that that might not be true.
Well,
is that inside or outside your narrower subset of Article 2?
there is authority that is inside. There are decisions in Edwards and Amin, which are both prison death and custody cases, which our Court of Appeal comments on in its decision in this case. So they are seen as a category of cases which more readily gives rise to a revived Article 2 obligation. Now, that's different from this scenario, because here, this isn't a case where there's a confinement. This is a case where more might have been done in order to alert, but wasn't done.
What's the difference? I can't see the difference.
Well, because the custody case is a situation where it's a completely state-controlled event. This isn't. The state didn't create the danger.
Not completely state-controlled. The prisoner is killed by another prisoner. The question is whether the state should have done more to prevent that.
Yes.
That's exactly the question here.
Well, our submission is there's a distinction to be drawn between the death and custody type case and this type of case, which is one of omission by way of possible negligence.
And what's the rationale for that distinction?
I think the rationale has to be the fact that the state already recognises a particular approach in respect of death and custody cases. The coronial jurisdiction is different in that context. There's a statutory obligation to conduct an inquest. Those are cases apart. There isn't a recognition here, generally speaking, that a negligence allegation in the context of a death engages in Article 2 procedural obligation. That's quite a far-reaching concept. And it's one that the Court of Appeal recognised in its judgment in this case. Ms. Justice McGuire says, he uses the language, it's a jump to move from the Amin, Evans, Honour Yildiz type case to this case. But concludes it's a jump that must be taken. So we have, at that point, moved away from the paragraph 71 paradigm in Brecknell into a different territory. Now, it's
The question really is, why should the Brecknell obligation where it arises be different from where an original obligation arises? I could see an argument that they don't have an obligation, that there's no arguable breach of the state's duty at all. In that case, you don't have anything to found the investigation on under Article 2. But if you do, why is it different when new evidence that would have made a substantial difference had it been known earlier comes to light later? Why does that alter the nature of the state's investigative obligation? There's no logic in that, is there?
It may be limited in terms of finding a rationale or a logic for it. If we are operating here as we are in a circumstance where the revival doctrine is based on the Strasbourg jurisprudence in Brecknell, the Strasbourg court went out of its way to confine it to cases where the new information was information in the prosecutorial paradigm likely to lead to identification and prosecution of the perpetrators. Now, what we do know about this case is that that's not where this is going. This is going to omissions, negligence, and insufficient activity on the part of the state.
Well, it might go to compensation, which was one of the things that was mentioned in Janovich.
Yes, but there's a vehicle for that. There is a civil claim for compensation. So, again, if Brecknell is an exceptional doctrine, a doctrine of exceptionality, and if there are existing vehicles that could discharge types of issues or concerns of compensation, then why is there a need for another Article 2 type investigation? Bearing in mind, Article 2 attracts all sorts of other obligations, temporal obligations, avoiding delay, independence, pace, speed. Those are factors that are imported in once you cross that line. So it's a judgment one makes carefully. And what we say is the Court of Appeal made the jump, in Justice Maguire's words, to extend the doctrine from the death and custody type cases, the Honor Yildiz case in Turkey, to this type of case. And it brings me again to the ULA type point. This isn't a situation where we're applying Brecknell. On its face, the Court of Appeal is acknowledging that it's taking the matter a step further.
Yes, but if you look at the critical paragraphs in Brecknell, which are helpfully set out in paragraph 83 of the Court of Appeal's judgment, paragraph 65 expresses the obligation of investigation in much broader terms than simply the identification and eventual prosecution of the perpetrator. And similarly, in paragraph 70, including in the text that has been highlighted by the court, one has a description of the trigger mechanism, that they must be sensitive to any information or material which has the potential either to undermine the conclusions of an earlier investigation or to allow an earlier inconclusive investigation to be taken further. And then it jumps from that in paragraph 71 to the passage on which I think you rely. Is that a fair characterization?
Yes.
Yes.
So those are background factors.
But is there any explanation, having taken a broad approach in the preceding paragraphs, why the court has confined the revival doctrine to potential prosecution of the perpetrator?
It will be said, I think that reflects the factual nature of the Brecknell case. It was a case where there was a potential prosecutorial outcome. That's one explanation for it. But again, clearly Brecknell was a Grand Chamber decision articulated for the purpose of giving general guidance, and it appears to be a confining analysis in paragraph 71. Reflective of the facts, but again, looking at this as an exceptionality doctrine, reviving Article 2 with all that brings is confined to plausible or credible allegations likely to lead to eventual prosecution or punishment. It narrows the scope.
Might it not be said that the pattern of reasoning in Brecknell is to move, which is quite common in Strasbourg authorities, is to move from general propositions, which you have essentially at paragraph 70, down to application in the particular facts of the case. So, which would tend to explain why in paragraph 71 there's a more precise focus on the particular facts of the case, but there doesn't seem to be anything in the judgment that indicates that the court was intending to detract from the generality of its observations in paragraph 70. Is there?
I don't think I can point to anything specific in respect of that. It is, I think, interesting to look back to KU sometimes in respect of this, and what the court, Lord Kerr's judgment actually, on this point is.
The record itself was a case that involved allegations of collusion by the police or security forces in a death, and that possibility is discussed. I don't think it's included in the passages you quoted. Well, yes, after the sentence you quote in paragraph 72. They then go on to give the example of where the assertion or new evidence tends to indicate police or security force collusion in an unlawful death.
So I'm not sure which paragraph I was reading from.
That's 72.
It's the continuation of 72.
We maybe need to look at what they say. Given this particular case, it's itself involved allegations of collusion. They don't come on to deal with that particular case until paragraph 73 and following.
Which page?
I'm at 1738. Yes, 75, they appear to accept that as an obligation to investigate allegations of security force collusion in the targeting of civilians. Although they say it's with a view to bringing charges against any suspect. I suppose they're envisaging the suspects might in that situation include police officers or members of the security forces.
Yes, if there's collusion in the death of a civilian, it seems to me that they are potentially perpetrators of a crime.
Absolutely.
Yes.
Well, they were accused of assisting in the killing, essentially.
Yes.
Yes.
Yeah.
Again, that's not the case we're dealing with
And
here.
this is a very different
Yes, it's a different case. This is a case where it's about the adequacy of the police response. So it's in a different...
But even if that disposes of the point that the President has made, there is still the oddity that we have the paragraphs before paragraph 71 setting out the investigative obligation in broad terms, and then out of the blue a statement that focuses on the prosecution and punishment of the perpetrator.
Well, it's speculation as to what the purpose of that was.
But it's hard to see a principle underpinning the restriction in paragraph 71.
C4, I think there's elsewhere in the Article 2 jurisprudence, it's commonly stated that the best discharge of the Article 2 obligation is one that allows for the completion of the prosecutorial process. So there are many other mechanisms to discharge an Article 2 obligation, but the best of those is to bring the perpetrators to justice through a criminal court. Everything else is a step back from that. So if we're approaching this...
That's going to lead to problems when you really want the investigation, in some circumstances, to look at how high up in the organisation the problems went, who knew what and when. And if you're going to confine it by saying, all right, well, perhaps when they mention perpetrators, they mean a broader range than just the actual murderer, people who helped the murderer. But then if you're talking about people within the state organisation, wouldn't you want to be considering information about who else knew about it, even if they weren't potential defendants in a criminal prosecution?
Yes, you would. And in a post-2000 case, you always would, because Article 2 would be built into the analysis. In a post-1990 case, you always would on the current arrangement. The question is, if we're going further back in time, whether or not there's an obligation generated or revived to do that, bearing in mind that the utility of the exercise will diminish with time. I mean, the value now of conducting a systems audit of what the police did in 1988 is limited. Because
Brecknell builds in that, because that's a further question that Brecknell requires, whether it's reasonable to have an investigation now in all the circumstances, given the lapse of time, etc.
Yes, and Brecknell also says that if you have a Brecknell revival, it may be discharged by simply assessing the credibility of the new information.
Are revivals confined to criminal cases? I mean, obviously, there are a lot of Article 2 investigations that have nothing to do with crime. For example, the deaths of mentally ill patients who haven't been properly supervised. Rabone would be an example. Now, if an investigation into a death in circumstances of that kind had not been properly carried out, and that became apparent at a later stage, or there was fresh evidence, and on your approach, there would be no question of there being any obligation to carry out further investigation, because there's no possibility of anybody being charged with a criminal offence.
That was only if we're relying solely on the Brecknell doc. Let's say, again, same rules apply. If it's a post-90 case or post-2000, there's not a problem. If it's pre-2000 and you've established genuine connection and you realise there's a flaw in the investigation, that might get you there anyway without going into Brecknell revival. So there will be non-criminal cases where you can have a genuine connection established. Brecknell is a very niche issue as a concept, and it should be subsidiary to the analysis.
But I didn't think Brecknell was limited to retrospective cases. Brecknell applies now, so I'm not quite sure why you say there's no problem for cases post-2000, because I thought Brecknell does apply, or may be needed, if you've got a case post-2000, a case in 2001, there was an inquest at the time. Now, last week, it emerges something that undermined that, then that you would have to rely on Brecknell to revive the Article 2 obligation. So let's not complicate Brecknell with the retrospectivity point. The question is, if what emerged now was in relation to a death in 2005, say, was something which did undermine aspects of the earlier investigation, but not in a way that might lead to the identification of a criminal defendant, are you saying, you seem to be saying, that the Brecknell doctrine of revival would not apply?
On its terms, paragraph 71, it appears not to apply.
Right.
Yes. I don't think I can put it any higher than that. That's what the jurisprudence says.
Well, if that's a submission, we've got it.
Yes, that is a submission. Turning then to the last point, which I can deal with very shortly. If we are in Article 2 territory via Brecknell or genuine connection, the question is whether or not the attorney is mandated by Article 2 to...
I didn't think that was the question. The Court of Appeal didn't decide that he was mandated. They said he had to reconsider the question. And so nobody's suggesting he's mandated, as I understand it. There's no cross appeal.
Well, that's helpful.
Well, I may be wrong, but is that not correct?
That's correct. The issue, if I put it this way, is whether or not, in this context, it was reasonable for him to have formed the view that the Article 2 obligation could be discharged by the availability of the civil proceedings, by the conduct of the police ombudsman's investigation, and by the other ancillary investigations that had taken place, or whether or not it was an inquest that was required to discharge that obligation. So that, I think, is a refinement of the issue. The point's a simple one. We say, actually, what's in play, as I've discussed several times in the course of these exchanges, is whether or not duties were breached in the way in which the police conducted the operation here. It was an elaborate operation designed to lure police and security forces into a situation where they would be put in peril, and they responded in a particular way. Now, there is a civil claim outstanding in respect of that, alleging negligence, and the attorney took the view that a combination of the existing processes, the police ombudsman's investigation, what had been done before in 1989, and the scope for the civil litigation was sufficient in terms of a means to discharge the Article 2 obligation. And again, the court will be familiar with the Article 2 rubric from Jordan and other cases, that it's an obligation of means, not result. And the view taken was that there were, among those various mechanisms, sufficient means to discharge the Article 2 burden if it was engaged.
Can I just check, where in the papers do we have the attorney's reasoning on this? Was there a decision letter or anything like that?
Yes.
Paragraph 38 of the Court of Appeal summarises his position as set out in a letter of the 26th of May 2015. That's on page 173.
There are various pieces of correspondence. I'm trying to find the best articulation of the position. There was a...
well, the Court of Appeal thought it was best set out in the final letter, which was the one I mentioned.
Sorry, I missed the page reference.
It's page 173 is where it's dealt with in the Court of Appeal judgment.
Yes. Yes, that letter's found in full at page 382. Sorry, that's not going to be the right page.
There were a series of letters, so that's the end result, I think. Summarised.
That's a reference to the pre-action protocol response correspondence, which is at electronic 542.
Sorry, where is the letter of the 26th of May 2015?
Page 542 in the electronic bundle.
I'm not quite sure how the Court of Appeal was able to reach the conclusion it did, because isn't the logic of Article 2 that either you have an obligation to carry out further investigation or you don't? But the Court of Appeal seems to have left it open as to whether there should be a further investigation or not.
In terms of remedy, certainly they indicated that there was to be no intrusive or mandatory relief. It was left back to the attorney to consider.
Well, they have a sort of, well, on the one hand this, on the other hand that kind of thing, and it's up to the Attorney General to look at it.
Yes.
And take account of the fact there's a civil claim and whether that will be enough and so forth, but I'm not quite sure on what basis that is left to the Attorney General as opposed to being something that the court has to decide one way or the other. Either he does have an obligation or he doesn't.
Or were they saying in effect that it was for the attorney to make the assessment referred to, I think in paragraph 71 of Bracknell, where it says there has to be a sort of review of what's been done so far and what might be gained by a further investigation.
Yes.
Is that what they had in mind?
I think that's what they're doing.
Because, I mean, I suppose it's theoretically possible that you could review what's been done, have regard to what might be achieved, and just say it would be disproportionate now to have an inquest, and therefore no obligation actually to request a further inquest.
Yes.
Yes, the Attorney General now having, now the court has decided that there is an Article 2 obligation, has to then reapply the test as to whether that obligation requires now an inquest.
Yeah. So in other words, if we're against you on the second issue, there is an obligation, but it doesn't necessarily transpose into directing a further inquest. There's a stage of assessment to be made.
Yes.
To take that further.
They said, for example, he would have to consider the availability of witnesses and the state of available documentation. He'd have to consider what witnesses were available and what documentation was available in deciding whether or not an inquest would play a useful, have a useful purpose.
Well, the statutory test.
They presumably didn't have that information before them.
The statutory test is curiously worded in Section 14. It's a question of whether the attorney forms the view as desirable, I think.
I think it's advisable.
Advisable to conduct or direct the inquest. So it's,
yes,
it's in those terms.
But that would, well, it would have to be, if possible, read in a convention-compliant way.
Yeah. I would have thought if the Article 2 obligation had the effect that you were required to have an inquest, let's say, in order to be able to compel witnesses, then the Article 2 obligation from Bracknell would spill over into saying you have to have you have to exercise the power in Section 14. But there is a prior question: does it go that far?
No. Yes.
The Court of Appeal, the approach they take, you have it at 195 of the electronic bundle, focuses on whether the court should direct the attorney to exercise the discretion in a particular way. And the court seems to be identifying various factors. 129, it's not necessarily that in every case the court imposes an obligation of that nature. And 130 says it's not so black and white, it's better the discretion of the attorney. So it's left back to him at that time to reflect again on the matter of the judgment of the court.
Re-exercise the discretion under Section 14 now, aware that there is an Article 2 obligation.
Yes. But in the exercise of that, he can also then, I think, properly factor in what else has been done, the utility of the exercise, where it might go in terms of producing outcomes. Looking again at the letter which the Court of Appeal flag, it doesn't appear in the body of the letter that the attorney is saying there that civil proceedings provide an alternative mechanism in this context. Certainly an argument that was canvassed before the Court of Appeal. It may not have been operative in that decision letter, but it was an issue for the court. And insofar as that's an issue of principle, can it discharge the Article 2 obligation? We say, as a matter of principle, yes, it can. The Mastro Matteo and Italy decision, which we refer to, makes that plain. Again, it's not a complicated advocate a point, but we have.
But if you're wanting to take us to an authority, I think we might leave that till after the short adjournment. We'll adjourn then and resume at 2 o'clock.